personal views and opinions expressed by our podcast guests are their own and are not legal advice or official statements by their organizations. Hello, my name is Debbie Reynolds. They call me the Data Diva. This is the Data Diva Talks Privacy podcast, where we discuss data privacy issues with the industry leaders around the world with information that businesses need to know now. I have a special guest on the show, Franklin Graves. He is an attorney. He focuses on emerging technology, intellectual property, and media law. He's also the inside counsel, technology counsel for HCA Healthcare. Also, probably one of the reasons why I know Franklin is we collaborated on an article together a couple months ago. We could talk about that. It's about child privacy, but also he is the creator of the website and a newsletter called the Creator Economy Law Newsletter. Well, welcome.
Thank you so much for having me, Debbie. It's been great to virtually connect with you. You're very active pretty much on every platform. And I love following along with the updates. And it's such an honor to finally join your podcast and get to talk through some of these fun issues.
Yeah, well, I am just over the moon that you agreed to do this podcast. I think the work that you do is so unique, and your newsletter is like stellar. It's unbelievable. The amount of detail that you go into, and like the links and all the references that you do, you tell you're really honing your legal chops, right? Because you back it up with the evidence and everything. So a lot of times I go on to your newsletter to do research. I'm like, Franklin, he had that link to so and so, and I go in there and try to find different things. So it is great to have you on the show, and you sort of crisscross all types of things in technology. And so I think that's the reason why I like your newsletter so much, because it does kind of go horizontally across all kind of data and tech. And so it has little cybersecurity stuff in it, privacy stuff, and you really go deep. So tell me a little bit about yourself, your trajectory, and sort of why you decided to do this newsletter.
Yeah. Oh, well, yeah. Thanks. So my background, I'm an attorney. So I know that you have a lot of legal professionals and privacy professionals that are listening, and cybersecurity professionals that listen. So I would lump myself into kind of the legal framework for most of that. That's kind of where my expertise comes in. And like you said, I learn week to week, because it seems like every week, if not monthly now, there's new laws coming out that all of us have to digest and kind of pull out and think through the ramifications of. And that's really what kind of spurred me to start the newsletter as well, was this concept of like, okay, I'm doing this already just personally, putting aside what I do for my day job. But like personally, I love keeping up with stuff like that. And then also I work with creators. And so I think back maybe almost 10 years ago, I probably would have been still referring to them as internet creators. But I think now the whole ecosystem has really taken off and taken shape. And so it's more so they're referred to as creators, and it's called the creator economy. And you capture both creators and brands and the platforms. And so for me, it kind of is a melding of so many different areas of law, areas of practice that I love and I'm fascinated by. And that's kind of where I came up with this concept of creator economy law, because it allows me to dive into all of that and on a week-to-week basis, and provide not only myself updates, but update others, and do what I was really just doing to begin with, which is staying up to date on stuff. But working backwards, I guess with my career. So yeah, I do. My day-to-day job is for a healthcare company doing IP, media, data privacy, AI, emerging technology work for a for-profit, publicly traded company. And then prior to that, though, I was working for Eventbrite, which is the online ticketing and registration platform. I was on their commercial team, so I was negotiating commercial contracts, like sales contracts, vendor agreements. And I think that it was so much fun when I was there, because I was right on the cusp of when GDPR went into effect. I joined that around like, I guess, May 2018 is when that went into effect. And so ever since then, I was getting a taste of it with my first job out of law school, which was for a global record label. And I really got into the weeds of negotiating DPAs and privacy clauses and privacy policies and all of that at Eventbrite. And that's kind of carried forward with me as well. But even before that, I was working for a record label in the music industry, and it was a global music company. And I had the opportunity to understand, okay, wow, this is what working at a global level looks like, and how there's so many different laws, not just IP laws, copyright, trademark, patent, and trade secrets, but also just generally, this is how the music industry works, and this is how privacy works. This is how you handle email list and customer communications, all that kind of fun stuff. And so I really kind of had the benefit, I guess, over my career. I'm about to hit 10 years of being a licensed attorney, of having my experience and my exposure across a wide range of issues and a wide range of industries. And so I kind of take that and in all my free time, I work with internet creators. I work with creators on a pro bono basis, just to help them negotiate a book deal they were working on, or understand, okay, here's kind of what fair use means and whether or not it really applies, and whether you can really rely on it, stuff like that. But then even now, like you and I got to talk to you about the privacy issues for creators as well, because it all is coming full circle, and you can't really operate in the tech space. You can't operate in the online internet ecosystem without really at least being able to issue spot.
Yeah. Well, it comes through. It comes through in your work. It comes through in the things that you publish, that you have this kind of like cross, industry experience and understanding. And this is kind of new, right? So, the idea that you have people who have these rights, it's kind of like rewriting the way people think about intellectual property, what's private and what's not, what can you use, how can you, move forward in your career. So those are all really great things. But let's start by talking a bit about the article that you wrote, that you asked a quote from me from, about children. So this is a really good article. I think I did a video a little bit while after that about this. So tell me a little bit about this article, and we can kind of discuss it.
Right. Yeah, absolutely. So the court case you're talking about that we've kind of talked about and alluded to is actually it's a class action lawsuit. It was filed in October of 2019. And with any class action lawsuit, you have to define your class of individuals that were harmed or that are seeking damages of some kind. And so in this case, the class was a class of children, and it was through their parents and their guardians as their representatives that the lawsuit was filed. And the claims really center around the use of targeted advertising. And I think your audience and you will know the tie-in there is, of course, the use of persistent identifiers, those persistent IDs, and those, of course, tie directly back into the platform on which children are watching videos. And so the lawsuit was really centered on how YouTube, which is a division of Google and larger than that, Alphabet, YouTube was using targeted advertising. And in the process of doing so, they were collecting data. They were tracking the behavior of their users. And the problem there, though, is those users were children. They had a lot of children's programming and content that was really pulling in those audience of young viewers and young eyeballs, for lack of a better term as well. And the problem being is that by just going onto YouTube, anybody could access it. You didn't really have to be logged in or not, or if you were logged in, you were accepting their online terms, but can children consent to those is a whole other issue. And so YouTube, in order to fund its operations and to pay creators later on, and as it became more established, was collecting the data, the viewer data, and also the online behavior of children, both within its own platform, kind of what they watched, how they watched it, all of that. So that lawsuit, that class action was filed again like, why are we talking about a 2019 class action that was filed? Well, in August of 2021, the district court was upholding a motion to dismiss that was filed by YouTube and the channel owners. So then, of course, that means that they were going to lose their case. If it gets dismissed, then then what happens? So the class of children, that's like really sounds really weird to call them that, but that's kind of how you refer to them in these cases. The class of children, through their attorneys and their parents, appealed that dismissal. And the appeal goes to the Ninth Circuit, which is the Federal Court of Appeals. They ended up overturning that lower court's decision to dismiss the lawsuit, and they were allowing the class action to proceed forward. And so really the highlight that I have here for creators and for brands, I know a lot of people think, oh, YouTube, it's just anybody can upload content. But in reality, there are a lot of brands, there are a lot of corporations that have account that release content that may or may not be targeted towards children. And so the takeaways are really kind of understanding, okay, there's a lot of liability that can come about just by sharing content online. And so historically, I think we've seen a lot of lawsuits filed against the platforms themselves and the ways that they were acting, and or in some cases maybe not acting to protect privacy or to overshare information. I mean, with Facebook, you have the whole Cambridge Analytica and a whole laundry list of issues that you can probably go into, especially if you start looking at it overseas. So in reality, what we're looking at here, and kind of why I think this is an important case, is the exposure to individual channel creators. So in this case, it was both, like I said, that mix of brands. So you had Mattel and Hasbro and DreamWorks Animation, but then also looking at it, you have individual YouTubers. And arguably whether or not he is a individual YouTuber anymore is up for debate. But Ryan's World, or Ryan is the YouTuber, that the child that would unbox and play with toys and started out that way, multi-million dollars, tens of millions of dollars industry now. But the other issue here is there was also an independent YouTuber that was mentioned, and the channel has since changed since the lawsuit was filed. But the individual YouTuber was creating content that was the same kind of thing, unboxing toys, stuff that children would really want to be watching, like including in the thumbnail images of toys and all of that the cartoon characters that children would recognize, just to entice them and help them to click on the video and have those engagement numbers and the watch time increase for YouTube, which is very important for the algorithm to then know, hey, we need to feed this to other users that are enjoying and consuming similar content. So yeah, that's kind of the brief overview of why we were here with this case. And then I think, as you know, you mentioned in your video, is also the tie back to the 2019 settlement with YouTube between the FTC, so the Federal Trade Commission. And that, I think, is really important to look at, because in those documents that were filed by the FTC in connection with that lawsuit, and not lawsuit, but the settlement agreement and all that with YouTube, they mentioned some of these specific channels that then a class action attorney came along and was like, oh, here's a good group of people that we can file a lawsuit against and maybe get some money and have children, a class of children that were clearly harmed or arguably harmed by YouTube and Google's activity. And here are channel owners, content creators, big brand companies that are targeting them and trying to get them to watch. And so all of that plays in with the privacy law claims that can be brought against them.
Absolutely. And there's another kind of blockbuster theme that's running here that you and I chatted about, and it has to do with preemption of privacy laws. So part of the reason why this lawsuit was kind of revived is because the people who are ruling on this, the judges that were ruling on this, said that there was a claim here that this case should be dismissed because the U.S. has a federal law called COPPA around children's privacy. And then because of that these state claims, they should kind of dismiss it because COPPA handles kind of children's privacy. And so one reason why this was overturned is they were like, well, states have rights, states have laws. They don't, just because there's a federal law, it doesn't excuse you from these other state laws. And I think this is this is the crux of the problem that we have in the US, and the reason why people don't really understand why we don't have a federal law right now. So states have rights as well, and it may not be the same as federal rights. So even though some federal laws can preempt certain things, but they can't preempt everything in the state law, right? So some state laws have things called general applicability, where and on a federal level, they may be more narrow in the scope of what they can do, where states may have more latitude. And so that means that a federal law doesn't necessarily cancel out what's happening at a state level. And this is, to me, is like one of the biggest issues in the US around privacy law, and the reason why we can't seem to get anything done, because people think, well, let's get this federal law and it's going to preempt state law. I'm like, no, it won't. It may preempt some state laws, and it may actually stop other states from trying to pass laws. They feel like the federal law sort of takes care of it, but it doesn't stop states from being able to pass things that are outside of the scope of what kind of for example, the FTC can regulate, what commerce can regulate, and things like that. So what are your thoughts there?
No, I think you're spot on. I think that's a really important thing to note, and a very nuanced distinction, like you mentioned, for the US and the situation. I think that's one of the important takeaways here is a lot of brands and creators and even platforms recognize, okay, so we have the Children's Online Privacy Protection Act. That is only enforceable by the FTC. And so they might work into, like, this is terrible, but they might work into their business model and understanding of, okay, the fines that we're going to get from the FTC, because they're the only ones that can bring action under that, are going to pale in comparison to the revenues that we'll generate or the value we'll add back to our shareholders. I'm not saying that's what these businesses were saying, but that kind of risk analysis, that business analysis really comes into play. And where I think a lot of that is getting undercut is where state laws come into play. And we're seeing that with the patchwork of state level privacy laws that are being enacted, or amendments to those that are happening, like in California. And the true question will come at a later date, maybe. Put a pin mark there with a question, put a tab there with a question mark. What federal regulation is going to come in and override CCPA or CPRA or Nevada's or what have you? And that's the question that remains. And whether they will or not, it's like you said, can Congress, can legislators get together enough to pass sweeping privacy regulation? Who knows? But until then, it is this thing. And I think for creators and brands, oftentimes it was like, okay, we have the FTC guidance and they can enforce against us for not properly disclosing something as an advertisement, for example. That's one way that the FTC can regulate, like you're saying, that relationship between consumers and people that are selling something. But in this case, a lot of brands and creators and people in the creator economy space haven't really been taken into account. Okay, now we have to be aware of, what are these other laws? What other pitfalls do we need to be aware of? And I think this case is perfect to highlight, okay, not everything is preempted by a federal law that you might have thought of. And now you have to be really doing an analysis on a state level of what state laws. And not to get political, but I think we're seeing that too with how platforms are being treated in certain states like Texas and Florida or other states in the US, or even outside the US. Entire countries are banning TikTok, for example. So what other external factors will be impacting a business model? And it's getting really difficult to predict in the creator economy space.
Yeah, I agree. I love this. Deep thoughts, deep chats with Franklin. Well, one thing I want to talk with you about is kind of AI, generative AI, chat GPT. Like, this is like a boatload of like privacy, IP. It's like a stew of all types of legal issues, all kind of intertwined in one. So tell me a little bit about this generative AI issue. Obviously it has privacy ramifications. It has IP. It has implications for people who are creators that are using information that's generated by this, especially if they're commercializing the work that they do. So just give me, riff on that. Tell me what's happening. What's going on?
Yeah. Oh, yeah, absolutely. So generative AI has exploded, of course. Generative AI tools. So that would be everything from Midjourney, which is the text to image generator. And the other one that's similar to that is Stable Diffusion and Stability AI. And then on top of that, you also have OpenAI, who has made headlines for DALL-E and DALL-E 2, which are also text to image generators. But then you throw into the mix, like you were saying, the stew, you throw into the mix of tools, chatbots, chat interactions with a large language model or an LLM. And that's really where things really start to get interesting. And GPT-4, that has also been announced and is currently in release as well, is a hybrid of all of that. You can drop in an image and have it analyze the image and do so much. So that takes it to a step beyond just a chatbot. So yeah, there are so many issues surrounding AI and artificial intelligence and ML or machine learning. And the way to look at them, I guess, briefly is AI is the larger kind of term that's used for artificial intelligence, and then within that you have machine learning or ML, and that's to overly simplify it. And then from there you have all these different tools that are either generative in their outputs. So like we were talking about, text to image, and it generates an output that is a usable, tangible, maybe a work of some kind, maybe it mimic artwork or an art piece, or it mimics a written text of some kind. Or it just is, take it to the video game example, you have one of these models thrown in and plugged into a video game, a non-playable character, an NPC. And that character is just sitting there in the game, and a user goes up to them somehow, depending on what technology is powering the game, and they interact with that character. And for all they know, it could be an NPC, or it could be just another user. And so it raises all of these potential concerns, both on like the use of it and the disclosure of using it, to how it's economically sustained, because generating a lot of these models is costly. It takes up a lot of server resources, and it has an economic, or has an ecological impact. And so I think the kind of taking a step back, one of the best ways that I kind of approach each of these issues is to understand, okay, what are the three buckets that I place stuff in? And so the one I've been really honing in on right now is the output. And that's really the third bucket of how I view any AI or machine learning technology. And so it's that output. What is the software? What is the algorithm? What is the model, the user's engagement with that? What is it output? And how is that? What are the privacy? What are the security? What are the IP issues surrounding that? And that's just a whole bucket of issues by themselves. But then the second bucket, I'm working backwards here. The second bucket is the AI tool itself. So the ML tool itself, the software that's being run. So that would be like Midjourney, OpenAI, or Microsoft owns GitHub. So GitHub's Copilot, or Microsoft's Bing, or Google's Bard technology that's getting implemented into a lot of their search and other tools. Those are the tools. That's like a second bucket of what we interact with. What levers can we pull to control the output? Are there any levers that we can pull to control the output? So for example, can we put in the individual's name in a text to image generator and say, okay, I want to create a comic book that has a character that is uniform? Because again, if I'm using Midjourney, I can't really control the output every single time to give me the same looking character. So I'm going to use Zendaya as the actress, as an example, and I'll use her as a prompt, her name. That way I can say, okay, give me a character that's doing X, Y, or Z, that looks like Zendaya, that is in this environment, what have you. And that way, every single time I will get the same looking character, and I won't have to worry about, okay, the AI or the tool that I'm using is just, we're going to randomly generate a character's facial features. And so that is a whole name, image, likeness approach, are all privacy rights and publicity rights issues that are all, again, state law, vary from state to state. Not to mention just general biometric information that has been captured at that point. So all of that is just really, it can be triggered just by using a tool itself. So what is the tool, the manufacturer, the provider of the tool, what safeguards are they putting into play to prevent that type of use from happening, if they even can at this stage? So that's the second bucket. And the first bucket, backing up to how the models are generated and created and put together, they rely on data sets. You have to have massive amounts of data to train and build up a model and train a software algorithm that this is a dog or this is not a dog, this is a fire hydrant. And so the massive amounts of data that it takes to do that, we've learned from some of the lawsuits that have been filed by Getty Images and others, that it takes billions of images to do that. And where do those images come from? Oh, across the internet. So sure, let's just grab all of those and not worry about what type of privacy or security issues or what type of IP issues surround that data scraping, content scraping. That's a whole nother issue. Is do you refer to it as a data set and data scraping, or is it truly taking content that is copyrightable or copyrighted and owned by somebody, and then pull that in, or their privacy right? And that's somebody's name, image, likeness, that's their face, that's their biometric information. All of that is data, yes, but is it fair to classify it just as data? Is that overly simplifying it? Is that making it seem like it's harmless? And I think that is important from a distinction and a discussion standpoint, is how that is referred to ethically, responsibly, all of those kind of keywords you hear surrounding AI right now. So those are the three buckets that I put any type of AI technology into, and kind of how I analyze, okay, what am I actually looking through here? Okay, I'm going to be buying and using this AI tool, which Adobe has recently put out theirs, text to image generator. Okay, they're upfront and they're telling us, okay, we built these models only using images that we had permission to use, and only from sustainably sourced, and people are like, there's a way to give payment back to them in some instances. Okay, that's a step forward in the right direction. It's not just scraped data and scraped content from across the internet. They're actually putting into the market what is arguably a sustainable, ethical, privacy forward model and tools that are based on their AI and ML models. So those are the types of questions that you have to ask. And okay, what are the downstream ramifications of using outputs that might be a mirror image of some model that you didn't even know, like a model, like a photo model or something like that? So yeah, that's my take on AI. There's still a lot to unpack. There's a lot of risk. There's a lot of liabilities that still surround their use, development, outputs of them, all of that.
Yeah, this is why I love you. Deep thoughts. I love this. You mentioned two things that I want to talk about. One is, and I've said this to people before, some companies, they're coming out with AI where they're saying, let's create an AI, maybe it's a deep fake or something, of someone that doesn't exist, right? So it's like a computer generated thing. But what if the thing that's generated looks like an existing person? And maybe you've done something that maybe could harm that individual. I mean, this is like totally like very future state. Like we're starting to see things creep up now in lawsuits that are currently going through the courts that are kind of trying to address that exact issue. What are your thoughts?
Yeah, I'm actually so glad you mentioned that, because I completely forgot. One of the reasons why I appreciate what Adobe has done is in their tool that they've rolled out. Adobe is part of what's called the Content Authenticity Initiative, the CAI, and it is a conglomerate, an open source set of tools that can be used by anyone that wants to join and use the open source tools. So that if I'm using Adobe's AI generative tools, it will, in the output, it will embed metadata that indicates this is generative art. This is a generative work. So that way it's clear and transparent to anyone that is processing that image. So let's extract that as an example. If I use my phone to take a picture, I could theoretically be using an iOS Apple device, and they could join the Content Authenticity Initiative or some other technology that comes around that validates, okay, this is a photo that was taken on an iPhone device, and that image was not manipulated. It was verified from the hardware into the software written into the image. And then I can go to Facebook and I upload that image to Facebook. And then Facebook's algorithms can know and can verify, oh, this is an authentic iPhone photo from this user's phone or whatever. And now we know, okay, we are safe to promote this or to surface this within our algorithms to other users. And the same thing with Adobe. If I'm using Adobe Photoshop or their generative AI tool, I think they have like three of them or two of them at this point, the metadata will indicate, okay, this is coming from a trusted AI source in that it's Adobe or some other company. It could be any other company that decides to join this. And so we know that it was properly and sustainably created AI, responsibly created AI. And I think that's going to be important going into the future, is understanding the authenticity of any content that we are consuming. So going back to your deepfake example, if there is no information metadata that can be verified from a tool that was used to create the deepfake, then in my opinion, at this point, a platform should not be promoting and should not be making that content either available at all or readily available or what have you, without some other check or balance, content moderation lever that's being pulled. And I think that goes to the heart of deepfakes as well from a privacy standpoint. Okay, I think that goes to the heart of a privacy concern. If I'm using a tool, an AI generative art tool that has been built on a data set that was, like I said earlier, billions of images scraped from the internet, then that's not responsibly, sustainably sourced. I'm using like food labels here, so responsible, sustainable fish, that's caught. But it's the same type of thing. And I think food labels have something going, because I think Apple, I love what they did with privacy labels in their app store. Kind of like they actually came out saying it's like a food label, it's like a nutrition label. And I think we're getting to the same thing with technology, is having clear, transparent labels for content. And then even within the AI space, okay, what data, what content was used to train a model that is powering an AI tool? And can I trust that the output is, even if it is similar to a human model that might have been in one of the photographs, there will be a waiver for that. That model understood, okay, I'm part of a photo session where I know I'm giving up my biometric information to be fed into an AI system. And I'm fine with that from a model standpoint, a human model standpoint, a human subject standpoint. And then that can perpetuate itself and can go have downstream impact of having sustainable, transparent AI that is the output of that. So where you have issues, though, is like with deepfakes. If it's going to intentionally be looking like somebody, or if I'm just trying to become a virtual influencer, a VTuber, as they are sometimes called, where I am using just generative AI tools that are just fly by night, have been created and aren't sustainably or aren't ethically created, then yeah, I could potentially run the risk of using a tool that is going to generate an output that might be similar to somebody, and I might face issues. I might have liability. I might have risk associated with that.
Absolutely. So I'm glad you touched on something that I would love to talk about. This is amazing. And that is the difference between privacy and publicity. I would love to chat with you about that. But before we get started, I want to bring your attention to cases coming up. It's kind of dancing around these issues, but I want your thoughts on it. So there's a case, a guy in Ohio filed a case against Ancestry.com around, and they're trying to create this as a class action. I think that they're at the stage where they tried to dismiss it and it didn't get dismissed. So it may actually end up to be a class action. So this guy, he's a guy in Ohio. He's filed a case against Ancestry.com. He says that Ancestry.com has used his high school picture in advertisements and then targeted. So they know they had his picture, they know his name, they knew the school he went to, they know the state, the city, state that he's in, and they use that to target people who possibly went to school with him or was in that city in order to get more people to sign up with Ancestry.com. So it is a privacy and a publicity issue, but privacy and publicity are different. And part of this lawsuit for Ancestry, they're kind of dancing around a bit. They're sprinkling in little things in this lawsuit around who has the right about publicity, right? Because publicity ties in commercialization of your image, right? So I don't want to put words in their mouth, but in a way, they're kind of saying, you're a guy in Ohio. You're not like a celebrity. You're not like a political person. You probably aren't commercializing your own image. So maybe this publicity claim doesn't fit you. But tell me about this, because I think this has like a huge impact on kind of creators.
Oh, absolutely. I think you're spot on. I'm vaguely familiar with the case you're talking about. I think that from my own understanding of everything, I would argue that just by being a high school student or a middle school student or an elementary or even a college, whatever level of student you are, by participating in the yearbook process, whether they do that anymore or not, I do not know. But I can easily see this becoming an outdated concept.
Yeah,
But
totally.
anyways, whatever the digital equivalent of that might be in the future, which would be a whole different discussion because of terms of service, privacy policy, all that kind of fun stuff. Anyways, putting all of that aside, I think that some of the inherent nature of a yearbook is that it is not going to be used for this purpose, that it will not be scanned and digitized and recreated. It is intended for I would argue, kind of like a private-ish use for anyone that went to that high school or alumni, or maybe there is an argument, okay, from a historical perspective, it's got value. But to the degree of using it for commercial speech and assigning a commercial speech aspect to this individual whose image was used to pull in and draw in their other classmates with their image is a huge issue. And I would argue that, yeah, that would definitely be within the right of privacy. It's all going to depend on the state. It's going to depend on whether that user even went to the website. They've been to that website before. Have they agreed to the terms? And then therefore are they now looped into arbitration, all that kind of fun stuff that goes along with it. But anyways, it actually reminds me of a case that I think Facebook, if I'm not mistaken, again, I'm going off the fly here. I believe Facebook was involved in a similar lawsuit against like a user on the platform back when you would go and you would like a business page or you would leave a business review. Facebook would just algorithmically and automatically pull in, and let's say I have friend Joe over there and Sally over here. Both Joe and Sally liked this local business. That business can choose to advertise, and part of that advertisement will say, oh, Joe and Sally, your mutual friends, have liked this business organization. That was a contested issue. And I think Facebook ended up either, again, I'm speaking off the fly here, so people should double check me, but I believe they had to update their terms and either did away with that practice or updated their terms where you could opt out of your likes and your engagement data being used in those types of situations. So anyways, to answer your question, I think that, yeah, there is an inherent distinction between right of privacy and right of publicity. Right of privacy, I view as more of an individual. I am a private person. I have aspects of my life. I'm not speaking for myself because I choose to be online. I choose to be publicly available. But theoretically, I'm an individual. I don't want people coming and taking photos outside my home on the street. And just because I have the windows open, they can take photos of me. I don't want any of that. I don't want them to find private facts about me and then start talking about that or putting out a book about it or having me portrayed in some Lifetime movie. That would be fun.
Right, right.
So yeah, so I view right of privacy as one's individual privacy. And again, it's going to differ based on the state statutes. But then right of publicity is when you have somebody who's reached that level of fame. And from a commercial standpoint, they want to protect their name, image, likeness. They want to protect their commercial value that they've built up and that their public image has associated with it. And so there are ways they can do that outside of privacy and publicity laws, or publicity laws in this case. They could take advantage of trademark laws. They could trademark their name, potentially. They could trademark their brands. They could ensure that their photographs would require a license if used for commercial purposes. And so another example, actually a really good example I would share is the drugstore. I think it was Dwayne Reed had taken a picture of Katherine Heigl. It was a paparazzi photo of her walking out of their store or holding a bag or something like that. And they had used it to be like, oh, look, Katherine Heigl shops here. This would be good enough for you to shop here too. That's a right of publicity issue because as a celebrity endorser, she makes quite, I would imagine if she chose to go that route, she would make quite a lot of money to be a brand spokesperson. And so that would be using somebody's public image, the reputation they've built up, all of that without their permission. So in the case you described, I think it's more of a right of privacy issue, a person that didn't want to be used in that way.
Right, right. I think so. The way that I try to explain it, to me, privacy is about your right not to share, and publicity is about the right to control what is shared about you. If they consider you, and this is a whole other thing, this is why this is really important. If you're considered notable, like if you have 100 followers on Facebook, are you notable? You know what I'm saying? So I think that that's what they're getting at. This guy he's not a celebrity. He doesn't have like a big following or whatever. So I guess they're trying to play with the idea of like who has the right to protection or control of their image under kind of this publicity area.
I'm working on a book about creator economy law, and that is one section that I have outlined out. I have yet to get there yet. I know that there have probably been arguments. I think I've seen them before of, okay, well, this person has a public Twitter. They have a public Facebook. Why are they not considered to be wanting fame, wanting recognition? Why do they not want to be infamous versus famous and all of that? That's definitely an issue that I would love to explore more. And I myself have it on my list to get to eventually.
Yeah. Well, I'll send you over my research on this case. I just find it fascinating and I've been watching it really closely. What other things are happening in the world right now that concern you beyond just kind of AI? Obviously AI concerns you, but concerns me as well.
I would say just generally all of the internet laws that are coming out of Europe. I think that, especially relevant to your audience, I think that we are facing a time like we were back in 2016, 2017, leading up to GDPR going into effect. Yes, there are laws that are only really impacting and targeting EU citizens or EU data subjects, or their laws are impacting how internet users in Europe are engaging with an internet platform or a marketplace, or how an algorithm is impacting them. But I think we're at a point in time where, again, we have the EU that is doing stuff that is going to impact how services, how products on the internet are delivered across the globe. Because it's, as we learned with GDPR, with privacy laws, it's nearly impossible to segment out your business and to segment how your products and services are delivered. And I would argue it's even harder to do so with these newer laws, with the upcoming AI Act that's been proposed, or the Digital Services Act, or the Digital Markets Act that are passed and are coming into effect soon. It's going to be hard because I think we've been working through it on the privacy side as US-based companies or Canadian companies or any other company outside the EU, where, okay, maybe I just need to spin up a server in those jurisdictions. And maybe I can tweak my privacy policy this way, which I'm making it sound very simplistic when I know you and I both and your listeners know that is far from simplistic. But to have data practices that are siloed and geo-specific, I'm having a hard time seeing how, from a cost perspective, that's going to be extrapolated out over so many other areas of a business operations, not just what we now have as privacy silos within a company or the security silos within a company, where you have maybe your chief security officer, your chief information security officer, your chief privacy officer. But now your other teams across the board are going to have to be thinking about it. And I think maybe a precursor we're seeing is now a lot of these privacy laws are starting to impact those previously carved out areas like HR, all the data surrounding HR applicants, or job applicants, or,
right, yeah.
or your employees. And so I think it's starting to get larger in scope, and the EU is really pushing this forward much more quickly and swiftly than we are in the US. And I see that as a huge concern just for me, both in my professional capacity as well as my personal capacity covering what I cover and staying up to date. It is rapidly changing. And again, I think we're going to see the EU doing stuff that is going to have a global impact, not to mention the
Absolutely.
copycats that start to happen after that.
Absolutely. I agree with that 100%. Also, one thing to note is that because the EU has a human rights bent to things, the way that they pass laws, they aren't as prescriptive as they are in the US, right? So, where they're like, okay, keep data as long as you have a purpose for it, or, get consent, for, for whatever, where we're like, put a button on your website that says this. You know what I'm saying?
Yes.
So I think it makes it harder for us in the US to try to pass laws because we try to be overly prescriptive. And a lot of lawyers hate that. Hate laws that aren't prescriptive, right? Because you have to kind of figure out, it's not saying, the GDPR doesn't say delete the data every 7 years. Like people like love that. They're like, okay, great, I understand. I can like program this, but it's like, okay, tying it to a purpose, that's harder to do. And that's kind of a more company by company thing. And then also, even though I'm a privacy professional, I'm also a business person. So I know that privacy isn't the only thing that businesses have to think about. It's part of and parcel of what they need to think about. It's something that they need to think about early, definitely, but it's not the only consideration.
Yeah, absolutely. And the other thing that I would mention along the same lines that's concerning for me is we're in a very high growth stage of AI. Everybody wants it. The tools have become much more accessible, especially now with Google and Microsoft and Amazon and their cloud-based services offering AI playgrounds, for lack of a better term. Even OpenAI, they call it their playground, where you can go and experiment with it. The privacy concern that I see there that also spills out into IP concerns. And I have to give credit where credit is due for this concept, but the concept of once you train a model on data or content, how can you untrain it? How can you ensure that it's not going to crop up as like a algorithmic shadow or like a data shadow as the tool is being used? And an example of that is like with the FTC that we've seen twice now, if not maybe I think 3 times. They've required companies to not just delete the data sets and no longer use the data sets. They have to delete the models that were trained on data that was improperly gathered because of their privacy policy not properly disclosing it. And so Tiffany Lee has a great paper that I would highly recommend to your listeners. It's called Algorithmic Destruction. And it's by Tiffany, Tiffany, Lee, Li. She's a law professor with the University of New Hampshire School of Law and does a lot of stuff with Yale Law School, their Information Society project. She's the one who really kind of taught me, and I've been running with it as well, trying to really think through this. Okay, you have this algorithmic shadow concept where, okay, you're using data scraped from the internet to train up models. Okay, that data is most likely going to have some personal elements to it, some individual, personally identifiable information, what have you. How is that going to be reflected in the outputs of AI systems that are built off of those data models? And the algorithmic shadow is that concept of, okay, it's going to be there in some capacity. It's just when will it show up and how much will it show up? But the reason I mentioned that is because like on the copyright side, we're seeing that now. Okay, if an image by Andy Warhol was used to train an algorithm, that image is going to be present in some of the outputs. And I think that's what we're seeing, especially in the Getty Images lawsuit that was filed here in the US, and there's also one in the UK. A lot of the outputs have the Getty image watermark on them if you're using like sports and other images like that. And their complaint that they filed is fantastic to illustrate this. Maybe you can include a link to it on your show notes. But it's this concept then of, okay, well, if they lose this lawsuit, Stability or OpenAI, Stability AI, if these companies lose these lawsuits saying that there's no fair use or there's no carve out like the UK has, the text and data mining exception, to just freely gather this information, this content to train a model, and it's showing up in your outputs, or maybe it's not, you still used it to train. How do you untrain a model And that's what technically right now, from a technological standpoint, I think people are working on it, but it's really difficult. And so that's why I harken back to the FTC on the privacy side. Okay, you have to delete your entire model. That is going to decimate some of these businesses, both from a current product standpoint, product or service standpoint, and also the cost to retrain and build a whole new model that has properly licensed content, if that even possible.
Wow, this is mind blowing. Thank you so much. So, if it were the world according to Franklin and we did everything you said, what would be your wish for, privacy or data or creator stuff anywhere in the future?
So, specifically within the creator economy, I would love to see an approach that puts creators first. And I think a lot of platforms are doing this well. A lot of platforms are making sure that creators have the tools they need. And I think that we've seen a lot of great response from like YouTube, building in capabilities on their platform to indicate whether or not content is made for kids or not. And not only providing the toggle for that from a product standpoint, but also from an educational standpoint, building out massive amounts of help articles and help videos that walk people through what that means. And even also, again, on the FTC side, allowing toggles to identify when something's a paid disclosure. So I think that I'm happy to see platforms that recognize that creators and creators themselves as individuals, whether or not they're public figures yet or not, like we talked about, or they still have right of privacy issues, they're considering the fact that those individuals are humans that power their platforms. Without that content, their platforms would not have the daily active users that they have. And so I love being able to point to examples of where Meta has developed a creator program. A lot of companies are developing creator-focused programs and sustaining them and helping creators find new brand deals, for example, on a brand platform to exchange. Okay, you want somebody to sell this product. Okay, that product would really work well for my audience. Let's talk. They're facilitating transactions like that happening. They're facilitating and empowering creators to become educated. And so that's what I really love seeing and what I hope continues. And it touches on privacy because I think Adobe is doing that right as well with the way that they're providing creators tools that are economically sustainable, that are transparent, and also respect the rights of the creators on which those tools were built.
That is wonderful. Oh my goodness. Thank you so much. I have to say, for people, even if you're not a creator, if you're on the internet at all, you need to read this newsletter because you delve so deep and go across so many different things. I read it like religiously. Like I'll stop. If I'm looking at it at 2:00 in the morning, I'll stop what I'm doing and read it because I'm like, oh my goodness. And the information and the research you do is impeccable. So I look at your profile a lot to like pull up, oh, here's this case. Here's the filing. Here's the whatever. You're really, really on it. Actually, you recently did something about the U.S. Patent and Trademark Office. There's kind of a brouhaha about people publishing books using AI tools and them trying to figure out are these original works? And, so it's just going to be a very interesting time in the future around, these concepts about creation and how people protect their rights and protect their privacy and things like that. So thank you so much for being on the show. This is so much fun. It's going to be hard for me to stop talking to you. You have to talk more.
Hey, maybe this is a way that I can come back. It's been an honor. I love your podcast. I love your content as well. I really appreciate you having me on and occupy their headspace on with earphones, or if they're working out or driving their car, whatever they're doing. I appreciate their time as well, because I know you have a lot of great episodes and a lot of great content that they could be consuming.
Oh my goodness. Thank you so much. I'm sure we'll be chatting soon.
Sounds great.
Okay. Bye-bye.